viewers, it is very important for us carrying on our conversation on governance to look at corporate governance and commit ourselves to understand certain concepts that come with it and the problems facing corporate governance. But before we get to corporate governance, it is very important to give corporate governance its study background. It is likely to be said before in the history of corporate governance that it all began in the 19th century but became increasingly important with time after the Second World War, and especially in the 20th and the 21st century. It is a question of one Englishman by the name Salomon. Mr. Salomon was known to be a businessman producing boots, and he decided to institute a body corporate under his name, that is Salomon Limited, whose members were members of his family. He was the majority shareholder. But when Salomon Limited collapsed and was faced with a lot of debts to pay to the creditors, the matters went to court. The Court of Appeal was of the opinion that Mr. Salomon, having been the majority shareholder, was to meet the debt obligations. However, this was not the entire matter. The legal fiction or the legal myth about the company brings us to understand the distinction between natural person and legal person. Legal personalities in the two may vary heavily, but legal person is regulated fully by the law, by the statute. And in this case, we find that Salomon was found not to be responsible for the debts that was borrowed under the name of Salomon Limited, because simply there are two distinct persons at law. As much as natural persons have got rights and obligations, equally legal persons have got rights and obligations at law. It is the legal person vis-a-vis, in this case, is the company limited to bear the legal responsibility and the liabilities attached. The conception is from the following point, that legal persons have got both mind and body. The mind, because they behave and they can offend as well as they can be offended. They can sue as well as they can be sued using their own name. They have got judicial right. They can present their cases before the court. They can take matters to court for adjudication and judicial opinion. It is in this understanding that the House of Lords ruled that Mr. Salomon and his family members are distinct or are separate from Salomon Limited. Having understood this, we understand that corporate governance has got its own members. They are called in different names or using different references. Some people refer to that as board of governors or board of directors or board of executives. They can be the superiors or name them the seniors. But also it is important to understand that they don't own or the organization, the legal personality. They do not actually, in this sense, claim that the organization is them or the organization is an agency whereby they are the principals. The owners of every organization, for our understanding, are the shareholders. The majority shareholder is the owner of the organization together with other owners. They make decisions and such decisions are binding. There is solutions on behalf of the organization. In other words, they represent the organization at law. They represent the rights and the obligations of the company. But they have the limited liabilities. They have limited shares, and this is defined in the share capital that they hold. That is why the following concept comes: the perpetual succession. The perpetual succession simply means that when members of the governing body of the organization happen to quit or to retire, or maybe by death they are not in existence, then they are replaced through the law and procedures by new members. That's why I would like to emphasize the following points. First and foremost, the registration, or how to institute a body corporate that is defined within the law, within Companies Act of 2015 in the Republic of Kenya. And by that, the legal person assumes its rights and obligations under the law by the issuance of the certificate of incorporation. The second point that I would like to emphasize here is about the governing body. There must be a body governing every organization, and this must be within the memorandum of association. And there must be such body that hold the legal responsibility and liability at law on behalf of the organization. Third point, such organization having rights and obligations can borrow using its own name or under its own name or title, can lend, can acquire property, can dispose of property, can appropriate property, can expropriate property, and can as well be made accountable by its own organization through its rules and procedures and through the policies and articles of association. It is audited and it must again meet the tax obligations. It is again very important and crucial to understand that all this requires a certain code of conduct, because any malpractice or misfeasance within the organization can bring a dramatic situation. The incredible crisis faced by Nakumatt in the Republic of Kenya, Uchumi supermarkets, Tuskys, and this can bring a drastic collapse that may affect many people and may affect even the third parties. It may affect shareholders, stakeholders, its members, its investors, creditors, consumers. And it is in this understanding that organization can as well affect or harm the third parties, such as the environment and other institutions. Having this kind of understanding of harms created by an organization, we automatically, quote unquote, accept and admit that legal person is held legally liable for its actions, for its decisions, for its behavior and conduct. All in all, we know of incredible crises that faced Wall Street in the United States of America. In the year 2007, the collapse of Lehman Brothers, Enron, WorldCom. This follows up with a lot of crises that was caused by poor management, poor administration, or maybe some unethical behavior of the members of the board. Boardrooms can as well be very hot, and boardrooms can always determine the success and the failure of any legal person. It is in this sense we want to believe that corporate governance is critically important for any person, lawyers and non-lawyers, people in political science, people in other social sciences, and also people in the legal fraternity. And in this matter, it is very crucial to consider corporate governance and our study of the principles of good governance, because this is where things can get bad. And this is where organizations can find themselves in legal battle that may be very nasty and expensive for individuals that must face the liability at court. Thank you for watching. Peter here. It is very important that you subscribe to this intellectual and academic legal series that are more interested in discussing what matters and what is the matter with the law. Thank you for watching, and thank you for signing up to this video channel. Bye for now. Have a good day.